Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Thank you for joining today. This is Synergy Settlement Services webinar on resolution of ERISA and Medicare liens. And just a brief intro to me, I am Teresa Kenyon. I am the Director of the Lien Resolution Department here at Synergy Settlement Services. I am a licensed attorney in California and Kentucky. And prior to joining Synergy about 2.5 years ago, I spent 8 or 9 years with the Rawlings Company, which is one of those big subro vendors that takes the money from injured people's settlements. So I'm now on the bright side, and I've got a team that is ever growing. We now have over 215 years of combined experience in battling liens on both sides. So a lot of the team is also from the subro vendor side. So that gives us lots of great insight. Today's agenda is about lien resolution, so we're going to talk about lien resolution generally, and then otherwise focus on ERISA and Medicare. So for the ERISA liens, I'm going to talk about the assessment of the plan's rights, where it is that you should be looking for that information, what's important. Really focus on self-funded versus fully insured, because that is a very important distinction that goes into what those plan rights are, and then cover U.S. Supreme Court case of Montanil and McCutcheon, and just those important kind of guidance pieces that we do have from the courts. For Medicare, I'm going to cover the process for using the portal, because through that process you can actually see the things that are required to be compliant with Medicare. And then ultimately talking about Medicare refund, because that is certainly something that happens. If Medicare receives money because they've issued a final demand, there are certain circumstances where you can get that money back. So Synergy's Medicare refund team is great at that. So we'll talk about that a little bit as well. So let's talk about lien resolution generally. We call it the case after the case, because just when you think you're done and you finally have the settlement funds and you're ready to take your attorney fee cut and move on to the next case, you've got this case that you still have to handle. You've got this lien that's out there. And this is really present in almost all personal injury cases. There is somebody who paid for the medical expenses, and most likely they've got their hand out to get some reimbursement from that settlement pot. So what does it take to resolve? Well, the first thing you want to do is make sure you're identifying the interested parties. So really knowing who paid those medical bills is key. A couple ways to go about doing that, if you're not already, is to make sure that you're asking your client who covered the medical bills, getting copies of insurance cards, and then reviewing medical records, and particularly medical bills or other things that show that an insurance company has been billed. So that can give some guidance on who you've got to go reach out to. Then you've got to know the applicable law. So some of these are statutory rights of reimbursement, and then others are contractual, like an ERISA plan or even a FEBA plan that has some contract language that guides their ability to seek reimbursement. And then you've also got to know if it's state or federal law. So depending upon the type of health benefit it is, it could be either or in the case of Medicaid, possibly both. You also want to know what equitable arguments carry weight. So every case has hardship and has the need for making equitable arguments. And so it's certainly something you should put forward in everyone. It's what makes the case human. But there are certain arguments that carry more weight in certain circumstances than in others. So really building the case with that in mind is important. If you know you've got some liability issues, then make sure that you're getting that in writing while you're settling the underlying case. Same with pre-existing conditions and failure to diagnose and all of those kind of things. And finally, what does it take to resolve a lien? Hire an expert. So here at Synergy, we are your lien resolution partner. It is what my team does all day, every day. And so we are here to assist with that. Let's start with some discussions on ERISA liens. So for an ERISA plan, you got to assess the plan's right. So how do you do that? What information do you need? So for an ERISA self-funded plan in particular, you need the plan documents. That's going to be the SPD or the MPD, summary plan description, or the master plan document. And I'm saying or, but you really should have both. The ultimate most important thing that you want is the master plan. Our U.S. Supreme Court in Cigna v. Amara has said that the master plan is what actually governs the plan's rights. And the summary is just that, it's a summary. So you want to make sure that you are at least getting the master plan, although the subro vendor, the insurance company, whoever you're dealing with on this ERISA lien is probably very easily and readily giving you the summary because that's what they have and because it's what they update every year. So every year that they learn that there's some kind of loophole that maybe created some deficiency for them to collect the year before, they fix it in the next year's summary. The master plan, on the other hand, isn't updated quite as regularly. So that's why you want to get that, not only because it's what applies, but it also isn't changed as often. And then also the Form 5500. So it is a tax document. It's something for the IRS. It's not a guarantee of any bit of information, but it provides some insight on the funding status. So important to get either from the subro vendor, or you can certainly look it up on your own. Freeerisa.com is one place to find it. And also the Department of Labor has a way to search the employer group to see if there has been a Form 5500 filed. You also want to make sure that you are auditing these lien claim summaries. So I can tell you from my time on the other side that a lot of times it didn't seem like they were being looked at, or they weren't being looked at until the end. And that's actually, it discredits you on some level with the lien holder if they've sent you 5 copies of a claim summary and you never argued that something wasn't related or shouldn't be there until after the case settles. They really don't look at that favorably. So take a look at that claim summary, look for the billing codes, make sure the providers match, make sure that the dates are not ranges, that it's not for like a 5-day visit all bundled into one lump payment. You want to make sure that that's actually broken down so that you can ensure that it's correct, because these liens are being built by mostly checking boxes or just kind of pulling it into the lien. It doesn't necessarily mean it's correct just because it's there. And then again, understanding the applicable law of the ERISA plan. So if it's a self-funded plan, it's going to be federal law, which then turns to the policy language. And if it's a fully insured plan, it's going to be state law, which then might have some more equitable arguments or other things that you might be able to pull into your negotiations. Now, the most important question on an ERISA plan is it self-funded or is it fully insured? Because that is what dictates the law that applies to that particular plan. So self-funded ERISA plans preempt state law. That has been the way that it's been for quite some time. U.S. Supreme Court said so. And fully insured are subject to state law. That's a little bit more open to debate depending upon who you're talking to, but most subrogation vendors will accept that if it's a fully insured ERISA plan, that it is subject to state law. We do see some arguments on the other side, but that's really more envelope pushing and trying to see what they can get. But for the most part, this is accepted in this lien world. So the problem is that it's really hard, especially even for your client, to know the difference because it looks the same. They have health insurance through their employer, whether it's a self-funded plan or a fully insured plan. They have a deduction that comes off of their paycheck, every paycheck. It's the premium as far as they're concerned. The difference is where the money goes. So for a self-funded plan, the funds are held in a separate account that are meant to pay for all of the medical claims for all of the employees. On the other hand, the money that is collected through paychecks for a fully insured plan is then used to create a payment of a premium, and then the insurance carrier is the one that foots the bill, carries the risk in that way. But Again, the problem is that it looks the same. It still has Aetna or Humana or Blue Shield involved on both of them. The cards look the same. Everything's pretty similar. So the difference there is that they are actually paying for the claims from different accounts, but they are still processing the claims the same way. So the Humana claims department is receiving bills from the hospital on the self-funded plan and on the fully insured plan, and they are applying a contractual rate and they are making a payment, and it all looks just the same. It just depends on where that money is coming from. So for these self-funded plans, the money is coming from that separate account, and for the fully insured plans, the money is coming from the big risk pool that is United Healthcare, for example. Now, the main recovery vendors, these are the big ones, the ones that carry the most lien files and have the most insurance clients. But we've got Optum and Equian, who are now together, but you still do see Equian's name in some places. Conduent, Rawlings, and then there's a lot of internal units with Blue Cross Blue Shield, Humana, and then there's also various defense firms that handle subrogation for other kind of insurance carriers. But the key to know, the key thing to know on anybody that you're actually conversing with on the other side is that they're highly trained, but with very narrow arguments. So they've been taught that this is the way that this is, and this is how I respond to you making this argument. They're not real open to the gray space that definitely exists in this arena of lien resolution. They use a lot of form letters, so you might spend a lot of time drafting a great argument on why they are not as strong as they think they are, and you get back a form letter that doesn't seem to address any of your arguments. That is by design on their end, one, so that they can churn through these lien files as quickly as possible, but also because they don't want them to be aware of all the other arguments that might be out there. Many of the representatives that you're talking to from these companies have 600, 700, 800 lien files that they're handling at any one time. I've even heard 1,000, 1,500 with certain subsets. So a lot of files that they are dealing with on a regular basis. A lot of structure with these companies. So they've got limited authority to reduce. They themselves might be able to reduce up to a certain dollar amount, or based on a particular percentage, and then otherwise they have to take it to somebody else for that approval. So that means that file is getting reviewed, call it a quality check or some kind of checks and balance, but there's definitely some levels there that make it so that the person you're talking to probably isn't the one that has the ultimate authority to approve that reduction. Many of them are incentivized by bonus. Some of them are incentivized by reprimand or not being reprimanded. But for some of these companies, the check that they receive from your office is a direct result of how much money they're going to have in their bank account that for their paycheck that particular pay period. So every bit that they reduce for you is actually coming out of their paycheck. So that's a big incentive that you've just got to be aware that is there. Also, with the reprimand piece, if they don't receive the documentation to prove what it is that you're asking them to do, then they could get dinged on their file. They could lose the ability to get new files. They could perhaps only get a lesser dollar file, which then impacts their pay. So there's lots of different things that can come into play depending upon the company. And really with these recovery vendors, and even with the in-house subro for insurance companies, they handle all the lien types. So it's not just one. It is ERISA, it's Medicare Advantage, Medicare Supplements, Medicaid, HMOs, FEBA plans, non-ERISA plans. I mean, there are all types that you see with these companies. So I wanted to briefly cover the U.S. Supreme Court cases. There's been a handful of them, but this is just two. The first one that's here is the FMC Corporation versus Holiday. This is where it was stated that ERISA self-insured plans preempt state law. So that's definitely a given. If it is a self-funded plan and it's ERISA, then it's going to preempt state law. So a lot of times I see attorneys still trying to argue the state law, and it's kind of, it doesn't carry any weight. So I would certainly save those arguments in those situations, because it's just not going to get you where you want it to get you. The U.S. Airways versus McCutcheon case, that's from 2013, and it was ultimately sent back down to the lower court after it went to the U.S. Supreme Court. But what really came out of this is that the plan documents control. So the plan documents are what provide the guidance for that particular plan. So often I'm asked, like, well, can ERISA self-funded plans do X? And my answer is always, what is in the policy language? Because that's the law for these self-funded plans. And as I mentioned earlier, you want the master plan document, not just the summary plan, because that's where you're going to see what the plan can and cannot do, or you're going to read in between the lines in that situation. Now, because the plan documents are what are the governing law for these ERISA self-funded plans, you want to make sure that you're getting the documents. So you can certainly ask the subrogation vendor to provide them to you. They're going to give you what they have. They're going to give you what they want to give you. But ultimately, your client, as an ERISA plan participant, has the right under the ERISA statute to request all kinds of things, but particularly to request the plan documents. So we call that the 1024B4 request, and there is a penalty that is associated with it. It could certainly be a negotiating tool, but for the most part, in order to get that penalty, you have to file an action against the employer group for failing to provide the documents. But really, this is where you are getting the summary plan description, the master plan description, possibly that Form 5500, directly from the employer, directly from the self-funded plan. So you are not getting it from the subro vendor, like a Rawlings or a Conduent. You are not getting it from the insurance carrier, like a United or an Aetna or a Cigna. You're getting it directly from the employer, which is straight from the horse's mouth. Now, one question that I'm asked a lot is, do I have to put that insurance carrier or that subrogation vendor on notice? I haven't heard from them, so I'm good to just settle this case and disperse funds, right? And our answer is always going to be no. It's a risk, right? So our position is the best way to handle any possible lien is to actually handle the lien, tackle it head on. If they don't have a right, tell them so, make them go away. If they do have a right, you don't want them coming back after you've closed the file, dispersed funds to your client, and then now all of a sudden you've got an angry client wondering why the Rawlings company is calling them and asking them for $20,000. Now, most of these policies, these health insurance contracts, have a duty to cooperate in them. So I've got a couple samples here that I wanted to cover just to make sure that everyone knows what they're looking at. So this is inside that 100-page document, a 100-page summary plan or master plan description, and it's usually in the 2 or 3 pages that covers the subrogation and reimbursement section. So these again are just a couple examples, but you can see here that they put in there that as a condition of receiving the benefits, that the member must notify the health plan of when they're pursuing some kind of claim. That might be by filling out a questionnaire that sometimes your clients receive in the mail. It also includes a duty to provide a PIP log or a no fault if there is that other kind of coverage available. But there's a lot of cooperation that is expected here from a plan when there is this kind of situation. So again, back to the original question of, do I have to notify them? This is often where it ends up coming from. If you do ignore them and then you say, I didn't know that you were out there, they're going to point to this and say that there was a duty for you as the representative to the injured party to notify their plan that this was taking place. Now, this is actually in that same plan that I just showed on the previous slide, but this is kind of a clear what happens or what could happen if the member does not comply with the duties or the reimbursement ultimately back to the health plan. So here it says that the plan has the authority and its sole discretion to deny payment of claims for future benefits. So that is certainly a risk. It's certainly in a lot of these policies, but it's not in a lot of other policies. So this is where it's important to get the documents and kind of see what the risk is. This also has, and I don't have it highlighted there, but that they can bring an action against the member to enforce this subrogation section. So that's, basically an action under ERISA to enforce the terms of this policy. And most of these policies that have that kind of wording also say that the injured party is then to pay for the attorney's fees and costs to pursue, because you didn't reimburse them outside of court. You've made them now incur additional costs, and so that cost is then passed on. So this is just an example of that. Now this is another plan, so completely separate, but you can see that the language is similar. The underlying content is the same, that these plans are putting the duty, or the obligation is the word they're using here, on the injured party to know that if they have some kind of liability claim where they are pursuing a settlement, that they have the duty or obligation to let the plan know and to cooperate with the plan to make sure that they get this reimbursement, to do nothing to prejudice the plan's rights. And really, this is an important section to kind of tune into whenever you are reviewing policy language, to see how extreme the duty is, because some of the plans don't have this at all. And that means that you'd have a stronger argument to say, I didn't have a duty to notify you because the plan said didn't provide that duty. But as I said before, so many of these plans do have it very clearly laid out that there's a duty or obligation on the part of the injured party to let the plan know. And just to provide a third example, these were all ones that I saw on the day that I was putting together this slideshow, so just threw them in here. But this particular one says that you're to notify the plan of pursuing, that you're to reimburse them for the full amount, and that the money is to be held in a constructive trust. I don't believe that the other two called it that as far as being a constructive trust. But again, if you fail or refuse to reimburse the health plan on this particular one, then they will withhold future benefit payments. So this whole idea of offsetting is something that is in a lot of these plans. It's not necessarily something that happens a lot. It's a risk. If they created a process on being able to actually withhold those future benefits, then it's something that you definitely have to consider. Like, if I don't pay you $10,000 now, you're going to just not pay $10,000 in future benefits. The problem is, though, it is in a lot of these plans, and it happens probably 5% of the time, if I'm being honest with what I've seen in all my years in this space. But it is just the risk that's there, because you just don't know. Are they going to do it or are they not? So what should you do? You should cooperate with them. You should deal with them. You should put them on notice. You should have the fight. And Synergy is definitely here to help you with that. Now, this particular section in a policy was something that I haven't really seen before. And it actually says if you are not reimbursed because you choose to not pursue a claim, then they will offset your future benefits. So this is actually a very, very extreme thing, because normally what these policies will say is that if you don't pursue, then you have to assign, or basically that you have automatically granted any right that you had to go pursue a claim to the plan. And that's basically their subrogation right. Like, that's what they claim anyway, is that they have a subrogation right to go directly to the insurance carrier, who otherwise could be held responsible, and to claim their own damages, their damages being the medical expenses that they paid out. But this here definitely seems like it took a much stricter position than what I normally see. So this could be a sign of the future for some of these types of plans. Now, anyone who has dealt with Medicare conditional payments will admit that it can be a time-consuming process, particularly if you're doing it right. There are multiple steps that need to be taken to get to the end result of satisfying the Medicare interest. Timing is important, and there are deadlines that need to be abided by. If something goes wrong or is reported incorrectly, it's difficult to get a live person on the phone. If you do get a person, they probably can't answer your questions. But the biggest issue that causes some confusion on the front end is that the defendant insurers are reporting to Medicare their own information because of their own obligations under Section 111, and it could be conflicting information than what your office is submitting to Medicare. So this, we see this most often with dates of loss that are somewhat vague or just not specifically determined, not as clean maybe as an actual car accident date. We see it as it relates to settlement amounts, particularly when there's multiple settlements. That can often cause confusion with Medicare and the injuries. So it might be that you claimed 4 injuries, and it might be that the defendant only accepted 1. Questionable as to what should be reported to Medicare. At the end of the day, it's probably should be equivalent to what the defendant reported, which is just that 1 injury that they accepted as related to the loss. We are going to go through the Medicare lien process. A lot of this is borrowed from the Medicare website. The Medicare website is actually pretty decent when it comes to providing some basic step-by-step instruction. So the first thing when you as the attorney know that you are pursuing some kind of claim on behalf of a client and that your client is a Medicare beneficiary is to report the case to the BCRC. And it's stated that the BCRC must be contacted if any claim is made against any alleged tortfeasor that has liability insurance, if there is no fault insurance involved, or a workers' compensation claim. So when you contact the BCRC to report the case, you want to make sure you have this kind of information. So just the actual beneficiary's information, you should probably have that in your file. So your client's name, their Medicare number, their gender and date of birth, as well as their address and phone number, and then some information about the case. So we want to be reporting the type of claim, the insurer's name and address, a description of the injury, and then the date that we're talking about for the injury or accident. So Medicare has a portal. This is a screenshot of the Medicare portal case reporting page. You can see that this is where you put all that information that we just covered. And this is actually, if this isn't something that you've ever seen before, worth checking out. It does make things easier, but this is definitely what Synergy uses as often as we can to handle these as efficiently as possible. So the second step is that the BCRC issues a rights and responsibilities letter. I've just got a screenshot here of what that letter looks like. So after the occurrence is posted, then BCRC sends this out. This letter explains what information is needed from the beneficiary and what information can be expected from the BCRC. Next step is that BCRC goes ahead and takes a look at the claims, and they identify Medicare's interim recovery amount, and they issue the conditional payment letter, the CPL. So they take a look at all the claims, and then based on the details that have been provided about the type of incident, the injuries that are alleged, they go ahead and put together a lien. Medicare runs from the date of incident through the date of settlement. So a lot of times when you have them when you request a conditional payment letter for the first time around, the case isn't settled yet, so it's not final. But within 65 days of the issuance of the rights and responsibilities letter, they will send the CPL letter and the payment summary, which lists all the items and services that they've paid that they're identifying as related to the case. This is just a screenshot of what it looks like. In this particular case, it says as of the date of this letter, based on available information, they've identified $2,700 in conditional payments that they believe to be associated with the case. And they're also saying that they enclosed a listing of the payments, that it's not final, and that you should obtain a final amount before settling the case. This is just a screenshot of what the payment summary form looks like, just in case you haven't seen it. So they've got the diagnosis codes. You can tell there that they list multiple codes on one line. And you can see what the billed amount is and then what the actual conditional payment is as well. I mentioned the Medicare portal a little bit ago. So it's the Medicare Secondary Payer Recovery Portal, the MSPRP. And I just wanted to highlight the kind of things that you can do in the portal if you're not already using it. Synergy definitely uses it for efficiency's sake. So you can submit beneficiary proof of representation, beneficiary consent to release, or insurer letter of authority documentation. You can also request the conditional payment information, so you can get that conditional payment amount. You can get the updates that way as well. You can request a printed or electronic copy of that letter, and you can also request a final conditional payment amount for a case that's approaching settlement. That's a whole other process that we do sometimes utilize. You can dispute the claims that are in that conditional payment. So if there are any claims that are unrelated, or if there's some kind of argument you can make as to why they shouldn't have to be paid back, you can do it through the portal. You can also initiate the final demand. If you agree with that CPL amount, then you can click the button and turn it into a final demand. You can view the status of any kind of communication that has been sent from Medicare. You can also submit the case settlement information. So when the case is settled and you want to go in and get the final demand, you can give them all that information, upload the settlement documentation to get that process going. And then finally, you can submit the waiver compromise redetermination request, the request for refunds right there in the portal. And you can also see the details of it, when they've received it, when they made a decision, and what the decision is. So that is certainly helpful. Sometimes Medicare does not issue a CPL, the conditional payment letter that we mentioned before, but instead they issue a CPN, a conditional payment notification. And this is done when Medicare finds out about the pending claim once it's already settled. And that is often the case if it's the defense that has reported it for the first time. So Medicare will send out the CPN. If you, as plaintiff counsel or the beneficiary themselves, send a response within 30 days, then the correspondence will be reviewed and a demand letter will be issued. That demand letter will include the procurement cost reduction. If a CPN is issued and they don't receive any kind of response from you as the attorney or the beneficiary, then no procurement costs are taken into consideration, and the demand letter that comes out is for the full amount. So it's always best to report the settlement, report the case to begin with, report the settlement information yourself so that you can make sure that those procurement costs are being considered. So there is a dispute process with Medicare if it's believed that any of the claims that are included on a CPL or a CPN should be removed from Medicare's conditional payment amount. Then you've got to provide documentation supporting that position and present it to the BCRC. The process can be handled by mail, fax, or through the portal. And if the BCRC agrees, then they will adjust the conditional payment amount to account for any claims that are not related to the case. Sounds simple enough, but there are plenty of times where you submit a dispute and they do not remove the claims. So oftentimes it is a multiple attempt to get the claims that should not be there removed, and we definitely have a lot of experience with that. So settlement has occurred. You are in receipt of funds, and the BCRC needs to be notified. So the details that they need are the date of settlement, and that's very important because that's when they will cut off the inclusion of treatment in their lien amount. The amount of settlement, that includes all settlements. They do have different files for a BI versus a UIM. If it all settles around the same time, it can be submitted as one. We do that sometimes. They also need to know the amount of any attorney's fees and costs because that is important to the reduction that needs to take place for procurement costs. And they have created a document that is called the Final Settlement Detail Sheet that makes it easy to submit that information to them. Got a screenshot here of it. It's just that bit of information, but it's just a clean way to submit the information to Medicare. After settlement information is entered, then the next step is for a final demand to be issued. So the BCRC will do a final look at the claims that have been paid by Medicare. They will apply a termination date to make sure that they're not including claims that are after the date of settlement, but they can add new claims. So these could be new claims that are prior to the date of settlement that never made it onto a prior CPL. And really, you could have received a number of CPLs over the course of your handling of the case. And then all of a sudden, the final demand has new claims. Maybe it's $20,000, $30,000 more than what the prior CPLs are. That does happen, and that's why they say that a final demand is not, or Medicare's lien is not final until a final demand is issued, because these claims that get added, they do remain if they are valid and if they are prior to the date of settlement. So the final demand will include all those claims, and then it will subtract the procurement cost. And then once that final demand is issued, Medicare must be paid its final demand amount. If not, then there is interest that is assessed. So we do recommend paying the final demand within 60 days, or else the interest will begin to accrue. And ultimately, if it's still not paid, then it gets referred to the U.S. Treasury for an enforcement action to recover the unpaid amount. We'll get to that in a minute. So interest does accrue if the debt is not repaid or not otherwise resolved within the time period specified in the final demand letter. And that interest is assessed for each 30-day period that the debt remains unresolved. Even if an appeal or a waiver is requested, the interest will continue to accrue. So it's strongly suggested that you pay the demand amount, no matter what, to avoid the accrual of interest. If the payment of that demand is otherwise unjust or unfair, then that's when the waiver or appeal is appropriate. And if it's granted, then a refund is issued. And finally, if the debt remains unpaid, then the next step is for a referral to the Department of Treasury. So you definitely don't want to get to this point, but the notice of delinquency is through an intent to refer letter, which is a notice of the BCRC's intent to refer the debt to the Department of Treasury offset program for further collection activities. The intent to refer is sent 90 days after the final demand letter if the full payment has not been received at that point. And if the full repayment is not received within 60 days of the intent to refer letter, which is 150 days from the final demand letter, then the debt is referred to the Treasury once the BCRC handles any outstanding correspondence that they may have. So CMS may also refer debts to the Department of Justice for legal action if it determines that the required payment has not been paid. And the law also authorizes the federal government to collect double damages. We've heard about that before, but the collection of double damages from any party that's responsible for resolving the matter but refuses to do so. All right, so we're going to talk briefly just about the reduction for procurement costs. It's thought of as being a given when it comes to these Medicare liens. And as you likely know, that there's two different methods. So one is simply a reduction of fees and costs from the Medicare lien amount. Medicare lien is $60,000 minus 40% fee minus a pro rata share of costs. But the other situation is a reduction of fees and costs from the total settlement, and then the final demand is the rest, which means that everything else that's left after you as the attorney take your fees and costs goes to Medicare, and it leaves nothing for your client. So neither of those ways of calculating a reduction take into account any liability-related issues, any policy limits issues, caps on damages, if it's a medical malpractice type of case. None of that is taken into consideration. And so this Medicare secondary payer statute has the repayment formula that is only designed to maximize the return of funds to Medicare, and it provides no consideration for the future well-being of the Medicare beneficiary. This is just a slide of the statutory wording for the procurement reduction. It's found in Part C of 411.37.
And then this is the Part D, which describes when Medicare takes what's left after attorney's fees and costs.
And that mostly concludes our webinar content, but I did want to just show a couple of results that we have received on ERISA and Medicare lien interest. So this demonstration here is just, there was an ERISA lien of about $300,000 that was being asserted as self-funded, and the subrogation vendor, who shall remain nameless, was demanding full reimbursement and claiming that it was a self-funded plan. Once the file came over to Synergy, we were able to identify that it actually was not self-funded, and instead it was fully insured, and made all sorts of equitable arguments and was able to reduce the interest down to $24,000. So big value that was brought here on this one. And this example is for Medicare. The Medicare interest was asserted at about $175,000, and it included a lot of possibly related treatment. In this case, the injured party actually died as a result of a medication error, and the medication error resulted in brain damage that ultimately led to the death. Synergy disputed claims using arguments that are often successful, but not necessarily always. And in this particular situation, Medicare eventually, after a couple rounds, did agree to reduce their CPL to $1,600, and then they applied the procurement costs. So this was on a 6-figure case that settled for almost 7 figures, and we were able to, again, bring huge value to this particular case. So thank you for joining. This does now conclude the webinar. I am Teresa Kenyon, the Director of the Lien Resolution Department here. If you have any questions for us, want to send over your liens, please call us here at this number, visit our website, or make outreach to your Synergy contact, and we are here to help you. Thank you.